4. Mumbling. Mumbling might indicate a person under the influence of alcohol or drugs or planning to jump the officer to make a getaway. United States Supreme Court upheld conviction of concealing a weapon, a felony offense in Ohio. An example of police department SOP for a stop and frisk, a frisk or feeling of the outer garments of an individual with the sole purpose of detecting a weapon. If during the pat-down for weapons we find drugs, and it is immediately apparent that we found drugs, the drugs will be admissible. Stop and frisk, gangs, facts. Albuquerque Police Gang Unit officers in mid-afternoon were patrolling the war zone, an area known for guns, gangs, drugs and violence. On a city sidewalk, less than a block away, they saw 3 males walking towards them. One male was a known gang member and drug dealer. The other 2 males appeared to be gang members. They did a stop and frisk of the 3 males. On one of them they found cocaine. A forcible stop or detention, more than a police-citizen encounter but less than an arrest, is a seizure under the Fourth Amendment. A stop must be based upon reasonable suspicion. It must be a particularized suspicion that the person stopped has committed a particular crime. The officers had generalized suspicions about gang members committing crimes. Do the officers have anything connecting this individual defendant to a particular crime? Is gang membership, standing alone, sufficient to support reasonable suspicion? Good stop? Good frisk? Will the evidence be admissible? Answer: the state lost this case. Officers had nothing connecting this individual defendant to a particular crime. Being a member of a gang is insufficient to support reasonable suspicion. This doesn't mean officers cannot be proactive. Officers can ask for consent to search. Defendant's behavior may also be grounds for a pat-down search. State v. Jones, 1992. Stop, reasonable suspicion. Facts: on the streets of Roswell, an officer beheld a strange sight. A car was parked, engine running, yet no one appeared to be inside. As he shined his spotlight, he saw a person slouched down in the driver's seat as if to hide. He said he was waiting for a friend. Meanwhile, his friend, defendant, left a nearby house and attempted to enter the car. Officer told him to wait in front of the car. He began walking away. The officer stopped him, did a pat-down, and found drugs. State v. Rivas, 2006. Good stop? Good pat-down? Will the drugs be admissible? No. Answer: an officer can detain someone when there is reasonable suspicion that a particular individual, the one detained, is breaking, or has broken the law. In this instance, there is no indication that the defendant had committed or was about to commit a crime. Court of Appeals held the detention was improper. The cocaine seized was inadmissible. Stop and frisk, violent crimes. Facts: radio dispatched a Hobbs police officer to a possible residential burglary in progress. The dispatcher advised 2 men were repeatedly going to the rear door of the residence and then returning to their vehicle. Officer arrived, saw 2 men leaving in a vehicle, and stopped them. Officer did a frisk, also known as a pat-down, and found a syringe in one pocket and cocaine in the other. State v. Cobbs, 1985. Was the stop justified? Yes. Was the frisk, pat-down, justified? Yes. Answer: the stop was good. The dispatch plus the officer's observations formed a reasonable suspicion that the 2 men might be engaged in criminal activity. The frisk was good. An officer has the right to frisk when a suspect is stopped for a type of crime for which the offender would likely be armed. Certain crimes are inherently dangerous: robbery, rape, assault with weapons, dealing in large narcotics actions, and burglary. Stop and frisk, nonviolent crimes. Facts: an officer in Lee County was dispatched to a robbery in progress at a convenience store. There was no robbery. The clerk was visibly upset. A very intoxicated male subject did not have enough money to pay for the items he wanted. He cursed and harassed the clerk and walked away. The officer stopped the subject. The officer knew that he had previously fought with police officers. He kept turning his body, as if hiding something or getting ready to confront the officer. The officer did a pat-down and found a pistol. State v. Haddenham, 1990. Was the frisk justified? Yes. Answer: our focus will be on the frisk. We need to articulate, list, reasons to justify why a frisk was done. Some reasons would include, the person was very intoxicated. The person had a record for previous disturbances with police officers. The person was acting evasive, with body language suggesting a confrontation. Court of Appeals affirmed conviction of felon in possession of a firearm. Stop and frisk, officer safety, facts. In Lee County, Officer A stopped defendant for speeding, 41/25. As Officer A approached the vehicle, he smelled marijuana. Defendant stated he had a rifle in his car. Upon exiting the vehicle, Officer A asked defendant if he had any weapons on him. Defendant said he had a pocket knife on him. Defendant acted real nervous and fidgety. After getting defendant's consent, Officer A performed a pat-down but didn't find anything. The initial pat-down was proper. But then, Officer B arrived. With defendant's consent, Officer A searched the car but didn't find anything. Officer A suspected defendant had drugs on him and asked Officer B to do a pat-down. Officer B saw a bulge in defendant's sock and found meth. Officers testified at a motion hearing that the purpose of the second pat-down was officer safety. State v. Pierce, 2003. Was the second frisk, pat-down, good? No. Is officer safety alone enough to justify a pat-down? No. What facts or reasons might be used to justify officer safety? Answer: Court of Appeals held that the second pat-down was illegal. Based upon the facts, the court felt the motivation for the second search was not officer safety but to look for drugs. Officer safety is a valid concern, but by itself the term doesn't mean much. We need to articulate reasons or expand on the term to make it mean something. Example: I patted him down for officer safety because he was intoxicated, moving his arms back and forth as if to fight or reach for a weapon, and was yelling at me. Stop and frisk, pockets, facts. Tucumcari police stopped a car because neither defendant nor his passenger was wearing a seat belt. Passenger was acting in a nervous manner. Passenger was patted down and arrested as a result of the pat-down. Instead of patting defendant down, officer asked him to step out and empty his pockets. Drugs, cocaine and marijuana, were found. State v. Ingram, 1998. A pat-down search permits an officer to pat down the outer clothing to feel for weapons. Did the officer exceed the bounds of the pat-down search in directing defendant to empty his pockets? Is this a good pat-down? Answer: Court of Appeals held the search was improper. A pat-down search, also known as a Terry search, for weapons may not be expanded into a search for evidence of a crime. In directing defendant to empty his pockets, the officer exceeded the bounds of a Terry search. Evidence suppressed. What is involved in an investigatory detention? An officer can forcibly stop, detain, someone when they have reasonable suspicion that the person has committed, is committing, or is about to commit a crime. We will now discuss what happens after a person is detained, the investigatory detention. Stop: investigatory detention, arrest doing an investigation. May clear subject or lead to an arrest. Think of it as a street stop or field stop or traffic stop. Person's freedom of movement is restricted, not free to leave. Detention is meant to be as brief as possible. If an officer determines there is no probable cause, the subject should be released from custody. Introduction to questions on investigatory detention. Some questions we will discuss include: how long are we allowed to detain someone? What guidance is there for handcuffing people who are detained? What issues exist regarding asking for ID? What issues regarding a show-up? Investigatory detention, how long? Facts: Clovis police were contacted by an informant who gave his name but asked to remain anonymous. The informant advised that defendant would be delivering meth in a pickup truck that had a personalized license plate to a named address. Information was proved accurate when defendant was stopped just prior to reaching the address. Defendant refused to give permission to search her truck. A drug dog was called and she was told she was free to leave, which she did. The dog, arriving 35 to 40 minutes later, alerted to the truck. A search warrant was obtained and meth was found in her purse and the truck. Defendant was charged with drug trafficking. State v. Robbs, 2006, was this a good stop?